Who are the members we have in person, Madam Clerk?
In person, we have Mr. Halan, we have Monsieur Brunat-Dussap, Madame Lalonde, Mr. El-Khoury, Madame Kwan.
Okay. Thank you. Good morning, everybody. I call this meeting to order. Welcome to meeting number 26 of the House of Commons Standing Committee on Citizenship and Immigration. Given the ongoing pandemic situation and in light of the recommendations from health authorities, as well as the directive of the Board of Internal Economy on Thursday, November 25th, 2021, to remain healthy and safe, all those attending the meeting in person are to maintain a 2 meters physical distancing, must wear a non-medical mask when circulating in the room, and it is highly recommended that the mask be worn at all times. Must maintain proper hand hygiene by using the provided hand sanitizers in the room. Please refrain from coming to the room if you are symptomatic. A reminder that all comments should be addressed through the chair. When you are not speaking, your mic should be on mute and your camera must be on. Before we begin, I would just like to indicate a few things for the upcoming meetings. On Thursday, our meeting has been canceled as another committee required our support. So this means that Tuesday, June 7th, will be the last panel on C242, followed by a panel on applications, backlogs, and processing times. So does the committee agree to clause by clause being scheduled on Thursday, June 9th for Private Members Bill C242? Is everyone in agreement? Madam Clerk, everyone okay in the room? Okay.
Madam Chair.
Yes, Mr. Janis.
I don't have a problem with the proposed timeline on clause by clause. But in terms of the second panel you're proposing for next Tuesday, I want to underline that we need to address and resolve the issue of the committee's privilege. So I believe there's some follow-up correspondence that one member is waiting for more information, but other than on the private members bill, I don't know that it makes sense to schedule additional panels on other studies until we kind of decide the steps we want to take as a committee. So we may need to have further discussion in that second hour on the privilege issue instead, assuming that we have the correspondence that members were looking for, and I think by then we will.
Thank you, Mr. Janis. Yes, I have written a letter to the clerk based on the clarifications which one of the members was looking for. As yet, we have not received any response. I will work with Madam Clerk to see when we can get the response from the law clerk. And once we have, then accordingly, we can look into in regards to scheduling something. So I'm still okay. Thank you. One more thing before we get into further things is in regards to budget approvals. I would like to request budget approval for the 3 following studies. Subject matter of Part 5, Division 23 of Bill C-19, an act to implement certain provisions of the budget tabled in Parliament on April 7, 2022, and other mayors, for an amount of $850.
I propose we should approve it.
Okay, are all other members in agreement to approve? Okay, done. In regards to Bill C-242, an act to amend the Immigration and Refugee Protection Act, temporary resident visas for parents and grandparents, budget in the amount of $7,575.
I propose this to go ahead.
Is everyone in agreement? Seeing no objections, agreed. In regards to application backlogs and processing time, total budget, which will include our visit also, if approved, in total of, no, so that's separate, sorry. Site visits is separate. Application backlog and processing times budget, $22,850.
Good idea. Good idea. We should approve it.
Is everyone in agreement? Okay, agreed. In regards to the visit, regarding our site visits, in the fall on our study of application backlogs and processing time. Please, I just want to let you know that at its last meeting, the subcommittee on committee budgets of the liaison committee examined the different travel proposals. It recently received and adopted the following motion. It was agreed that the subcommittee invite the Standing Committee on Citizenship and Immigration to prepare a detailed budget not exceeding $175,000 in relation to its travel proposal for its study of application backlogs and processing times, and submit it to the subcommittee by June 3rd, 2022. The subcommittee also adopted a motion that all travel budget requests presented to the subcommittee include a maximum of 7 members participating along with necessary staff. Does the committee agree that the detailed budget for the site visits to Abu Dhabi and Dakar in total of $170,697.47 for 7 members of parliament and required staff be approved? Is everyone in agreement?
Seemed like.
Seeing no objection, so is it agreed that the chair submit the budget to subcommittee on committee budgets of the liaison committee by June 3rd, 2022?
Agreed.
Everyone is in agreement? Agreed. So today, pursuant to order of reference of Wednesday, May 4th, 2022, we will resume consideration of Bill C-242, an act to amend the Immigration and Refugee Protection Act, temporary resident visas for parents and grandparents, Bill C-242, an act to amend the Immigration and Refugee Protection Act. Today, we will be hearing from our witnesses in the first panel. I would like to welcome Dima Ahmad, Executive Director, and also she is joined by Racha Salman, Program Development Lead. They are both representing Arab Community Center of Toronto. Today, we are also joined by Vince Langford, Director, Canadian Immigration Lawyers Association. Our third witness for this panel is Richard Corland, lawyer and policy analyst, representing LexBase. So thank you to all the witnesses for appearing before the committee today. All the witnesses will have 5 minutes for their opening remarks, and then we will go into our round of questioning. So we will start with Madam Ahmad, the Executive Director for Arab Community Center of Toronto. You will have 5 minutes for your opening remarks. You can please begin.
Thank you, Madam Chair, members of the committee, good morning, and thank you for inviting the Arab Community Center of Toronto as a witness this morning in regard to the Reuniting Families Act. My name is Dima Ahmad. I am the Executive Director, and joining me today is Ms. Rasha Salman, our Program Development Lead. We will both speak to ACCT's position on this bill discussed today. We wish to first express our thanks and appreciation to the federal government on its fervent commitment to the humanitarian values of Canada by consistently opening up opportunities for refugees and immigrants to relocate to Canada, particularly its recent commitments to welcome at least 40,000 Afghan refugees and unlimited Ukrainian refugees through various programs and partnerships. The prioritization of human life over financial interests has always been a characteristic of different Canadian governments, and we hope it will continue to be so for a long time. We have seen and experienced firsthand the challenges these populations face by having to leave their homes and seek refuge and a better life somewhere else. Some of these challenges are life-threatening, and world solidarity is much needed today. Indeed, with 26.4 million refugees worldwide, demand on immigration and refugee programs is only bound to increase, and we all must do our best to help. As an organization whose raison d'etre is to help refugees and immigrants, we deeply appreciate the government's understanding of this complex world emergency, and thank you for your continuous support of our mission and programs. We also highly value the opportunity to contribute to policy discussions such as today and strive to be a faithful messenger of the concerns and needs of a large and important chunk of the Canadian population. This brings me to our discussion today, and I'm going to start by going straight to the point. The ACCT supports the bill proposed by MP Seaback and considers it a great improvement to the original Super Visa program. I will get to our assessment of the bill in what follows, and I will also detail some observations we have and recommendations that we hope will feature in the coming discussions of this bill. When the super visa was introduced in 2011, it came as a welcome measure to reduce backlogs in immigration applications and facilitate family reunification. The flexibility of the super visa, as well as shorter processing times, were indeed great solutions for people wishing to reunite with their families for short periods of time. However, it is understandable that improvements to the visa are due. From experience and literature, the ACCT has learned of many concerns over the limitations of the original super visa. Some research suggested that due to its temporary nature, the super visa actually did not support family reunification and prevented families from making meaningful long-term plans. The cost of travel and insurance and minimum income requirements were thought to be prohibitive for many people. We have heard concerns that forcing parents to buy insurance for the whole year when they're staying for a few months made it impossible for many to apply for the super visa. Sometimes families or single parents needed help with child rearing, which back home was a job for the grandmother, and they couldn't afford daycare costs. One cited a monthly bill of $1,800. At other times, immigrants expressed concerns for parents or even siblings left alone during war or conflict when remaining members of the family have passed away or fled to safer havens. Many of those immigrants or refugees prefer to reunite permanently with their parents in Canada, but in the absence of a sponsorship opportunity, many resort to the super visa. Furthermore, some research in the past few years showed that super visa approvals were heavily skewed in favor of European or US parents or grandparents as opposed to racialized populations. Scholars argued that there was a much lower approval rate than US and Europe from the global South, such as Africa, Asia, and the Middle East, which meant that the super visa reinforced racial stratification. Finally, people on super visa cannot work. This means that while Canada might have visitors staying for up to 2 years and now 5, these residents who may well be as young as 45 or 50 cannot contribute to the economy. Having said that, the new bill comes with much needed improvements, extending the number of years of stay from 2 to 5, allowing insurance to be purchased from providers outside Canada, and addressing the minimum income threshold. These are excellent improvements, and we believe that it will greatly facilitate the lives and integration journey of many new immigrants. But we do believe that these measures should not be a substitute to the paths for permanent relocations of parents and grandparents. I will now give the floor to my colleague Rasha to expand on this.
As Ms. Ahmad, your 5 minutes are up. So you will get an opportunity when we go to our round of questioning. We will now proceed to Mr. Langford. He's a Director, Canadian Immigration Lawyers Association. Mr. Langford, floor is yours. You can please begin.
Madam Chair, honorable committee members, fellow witnesses, ladies and gentlemen, good morning and thank you for the invitation to participate in the study of Bill C-242. Canadian Immigration Lawyers Association was founded under the Canada Not-for-Profit Corporations Act on January 1st, 2021, with the purpose of promoting the rule of law, access to justice, and the development of Canadian immigration law and policy through legal research, education, and related activities. CILA currently has over 400 members, including lawyers, students, academics, and non-governmental organizations across Canada. A top priority for CILA is addressing the exclusion of legal counsel in Canada's immigration system. More information can be found at cila.co. Regarding the amendments proposed by Bill C-242, there are diverse views among CILA members. We absolutely support programs that will streamline procedures and facilitate family reunification while maintaining the integrity of our immigration system and social systems, including healthcare. We strongly oppose abuse by agents and members of the public that would take advantage of our fair and generous immigration system. Regarding the authorization of foreign health insurance, CILA acknowledges that additional competition in the insurance industry may benefit Canadian citizens, permanent residents, and their parents and grandparents who apply for super visas. I did a bit of research and found that there are at least 30 companies in Canada selling private health insurance for super visas. So it may be that competition is alive and well. Nevertheless, costs are very high, ranging from about $1,800 to over $5,000 per year for a 70-year-old with no pre-existing medical conditions. There is significant risk associated with authorizing foreign insurance companies. To maintain program integrity, we would not object to a limited number of foreign insurance brokers and underwriters being subject to equivalent standards to brokers and underwriters in Canada. We also recommend that any authorization of foreign health insurance involve robust information programs to make it clear that only authorized insurance brokers and underwriters are eligible to avoid the victimization of Canadians and their parents and grandparents. Regarding the proposed extension of the period to enter and remain in Canada under a super visa from 2 to 5 years, CILA is not convinced that the increase is necessary or advisable. I read the transcripts from the May 17th meeting of this committee, and it appears that there was a misunderstanding where it was stated that, and I quote, the original super visa allows the family to stay for 2 years over 10 years. And if extended to 5 years, quote, they could come for 5 months a year over 10 years. In fact, the super visa authorizes entry for up to 2 years at a time, not 2 years over 10 years. It authorizes multiple entries during its 10-year validity. A person could actually be in Canada for 9 years or more as long as they left every 2 years. Further, a super visa holder can apply to extend their temporary resident status from within Canada, and if approved, remain for longer than 2 years at a time. CILA foresees that if super visa holders are allowed to remain in Canada for up to 5 years at a time during its 10-year validity, they will have little incentive to maintain ties to their country of origin and residence there. On the contrary, more super visa holders may apply for permanent residence in Canada on humanitarian compassionate grounds, flooding what is already a limited category. H&C is an exceptional measure. It is not simply another means of applying for permanent residence in Canada. There has been and likely will continue to be more demand than supply for parent and grandparent immigrant visas, but it may not be prudent economically to expand this category. Therefore, the importance of the super visa to facilitate family reunification on an albeit temporary basis is critical, especially if Canada is going to continue to attract strong economic immigrants. Potential immigrants need to know that super visas facilitate parents and grandparents visiting, and the process is not too onerous. In summary, CILA recommends the maintenance of the super visa valid for up to 10 years, with admission for up to 2 years at a time, and the implementation of a stable, transparent, user-friendly parents and grandparents sponsorship program. Regarding the proposal to require the minister to prepare a report on reducing the minimum income requirement, CILA fully supports this element of Bill C-242 in further research and reporting. If the research indicates that reducing the income requirement enables Canadian citizens and permanent residents to leverage the benefits of parents and grandparents to work more hours, access education, and increase household income, then we would support a reasonable reduction in the minimum income requirement. Canadian Immigration Lawyers Association thanks the committee for consulting with us, and I am available to answer your questions.
Thank you, Mr. Langford, for your testimony. We will now proceed to Mr. Kurland, lawyer and policy analyst. Mr. Kurland, floor is yours. You can please begin.
Thank you, Madam Chair. It's a good bill. The 5-year duration is excellent. The insurance aspect, red flag, we may want to scrutinize Canada's international obligations to ensure free flow of goods and services. So we may not be able to limit or restrict the selection of an insurance product to a Canadian product only. Heads up for that. There are unintended consequences that will flow from C-242. And in theory, it's a nice portrait, but the practical reality is that after a 5-year period, we're going to see extraordinary numbers of parents, grandparents stressed, anguished at the thought of forcibly being returned to the homeland after half a decade with their family in Canada. That's cruel. So unless there's a kind of consumer protection waiver signed at the front end, this is a titanic, compassionate humanitarian disaster in the making. So here's the cure. Canada annually has a target, a quota, if you will, of parents and grandparents that will be allowed to remain or to enter Canada's permanent residence. Nothing wrong with that. The problem we have now, which will be sorely exacerbated if we bring in a 5-year super visa framework, is that every year people submit their expressions of interest to sponsor a parent or grandparent. And what used to happen every year, a lottery was held, inventory emptied. Well, we can't proceed along this path anymore. What should occur is that when there is an inventory of expressions of interest, right now there's close to 100,000, and we know that we're only going to select a range, let's say 30 to 35,000 individuals. You should not be emptying that inventory annually. Instead, when you are in the inventory, the floodgates close, no new expressions of interest are allowed to be uploaded into the system, and then you diminish the inventory every year by the number of parents and grandparents that you wish to select every year. What's the difference for Canada? 0. It's the same number of parents and grandparents. What's the difference for IRCC? 0. They're going to process the same number operationally. The difference is in the humans in the inventory. It no longer is a question of if I can sponsor my family member. It is a question of when. And so if you're going to pop a 5-year matrix, and you know that people are going to be stressing about being forcibly removed from Canada, you keep them in this inventory. Floodgates open, they enter if they wish to seek permanent residence, and not all do. They know that over the 3-5-year period, there's a high likelihood of being processed for permanent residence. And then you open the floodgates again and take the next batch. I'll leave that for now. In terms of eligibility on minimum income, here's something creative. We don't need to, we can lower, no problems with that. But what we should be doing is giving a credit, a $5,000 credit off that minimum income threshold for every child 12 and under in that family, because we need to reward the homemaker, the person raising the children. We need to understand the economic value of having a parent or grandparent take care of a young child, because it may free up a bio mom, bio dad into the workplace where they will be paying taxes to contribute to our economy. And those are my 5, Madam
Sorry
Chair.
for interrupting, Mr. Kerr. Your time is up. Thank you to all the witnesses. We will now proceed to our round of questioning. And we will begin our first round with Mr. Redekop. Mr. Redekop, you will have 6 minutes. You can please begin.
Thank you, Madam Chair, and thanks to all the witnesses. You've all provided some very interesting testimony. I just want to circle back to Ms. Salman. You didn't have a chance to finish, and Ms. Ahmad had mentioned some possible recommendations. If you could very quickly, very briefly, maybe list out those recommendations.
Thank you, Mr. Redekop and Madam Chair, and thank you, Dima. We had distilled our observations on the bill and the need for it not to replace the the path for permanent residence for parents and grandparents. And they basically focus on the cultural aspect, that family is multi-generational families are a cultural aspect of many immigrant families, and the need to expand our definition of family to consider newcomer family structures. It also focuses on economic and non-economic contributions of parents and grandparents, which is consistent with research as well, and basically allowing chances for productive aging. It has been mentioned how when parents and grandparents live with the family, they free up time and resources for the parents to go out and seek more employment and education. We also highlighted that many immigrants consider it their cultural duty to take care of their parents financially, even if they live in separate countries. So many immigrants are actually sending money abroad. So instead of taking trips to countries of origin or buying health insurance abroad, immigrants can spend these resources in the Canadian economy if their parents live with them.
I'm going to just interrupt you there because I only have a very limited time. I do want to talk about insurance, and I know that in our first meeting, there was a lot of discussion about this, and the Liberals on the committee especially were pretty concerned about the insurance. One of the considerations that was made clear was that the minister will have the ability to decide which companies are able to provide that insurance. So I just want to, there kept getting to be questions about this and if it would work and everything. And I would just like to know, because when I travel abroad to the US or wherever, I get insurance in Canada for my trip to that country. So I'm essentially getting insurance here for a trip somewhere else. So, why can't we allow the same for someone coming to Canada? So I guess I'd just like a little bit more information from each of you. And maybe we'll start with Mr. Curlin.
Yes, I think we can adopt a proven enforcement device that's used for designated educational learning institutions. We create an authorized list, a prescribed list, if you will, that specifically names an authorized insurance product or company. That way, we can monitor and control for enforcement purposes who's selling insurance product to whom, and we guard against the unscrupulous overseas companies. We have no defense against them. And so better to control it from Ottawa, if you will, with a prescribed list of authorized insurance vendors.
Mr. Langford, you had some concerns?
Well, I agree with Mr. Curlin, and I don't have concerns about a prescribed list. So if the minister designates a list of prescribed foreign insurers, CILA would be fine with that. It's just a matter of public protection and also protection of people that come here with some foreign insurance that doesn't ultimately pay their medical bills, and the Canadian system has to cover that. The other just note about insurance is that there is currently a gap in the system for super visas where a parent or grandparent coming on a super visa needs to get insurance for 1 year, but if they enter Canada and remain for 2 years, they could effectively save money and let their insurance lapse while they're here. And so that is something of note that is a concern, and they would be offside their visa, they would be non-compliant, and there could be potential consequences for that. But if they remain in Canada, they could effectively let their insurance lapse. So this has to be balanced with the concerns that were raised by the I'm sorry, I just want to get the name right, the Arab Community Center of Toronto, about the overall cost, that is, it is very significant, insurance costs. So hopefully what we could get to is a reduced cost with a foreign insurer that is reputable and vetted, and that there isn't a gap whereby parents and grandparents are letting it lapse while they're here.
Okay, Ms. Ahmad or Ms. Salman, do you have a thought?
Dima, I can I can take this. Actually, like to comment on the insurance issue, one of the things that we thought could help is allowing parents or grandparents to finance their own stay, and to allow flexibility in the insurance coverage by allowing it to be according to the length of stay. So, I mean, practically, why should they be forced to buy for a year if they only want to stay 3 months, for example?
Sorry for interrupting, Mr. Redekop. Your time is up.
Thank you.
We will now proceed to Mr. Al-Khouri. Mr. Al-Khouri, you will have 6 minutes. You can please begin.
Merci, Madame la Présidente.
Thank you, Madam Chair, and I want to welcome our witnesses today, and I want to thank them for their testimony, which is much appreciated by the committee. My first question is for Dima Ahmad. As you know, the super visa is a tool that allows for protection of visitors so that they can be supported by their children and have the insurance necessary to receive medical assistance if needed. Do you think that your community would benefit from the possibility of being able to buy insurance from international insurers?
Thank you. The truth is, for our community, the insurance cost is very costly, and it's prohibitive for many families to bring their parents and grandparents here. And that's why we one of the recommendations was, like Rasha mentioned, is to have it based on the length of stay. I might have missed a little bit of the question at the beginning because I didn't realize I was only on French. But for the communities that we serve, definitely having them flexibility with the insurance and having the ability to purchase from outside is something that might reduce the cost. So we would welcome it. But at the end of the day, we think that this is a temporary measure till they are reunited with their families through a proper sponsorship program. And I'm not sure if I answered the question.
It's good. Ma deuxième question.
My second question, based on your answer, Ms. Ahmad, I would like to ask a question to our two other witnesses, Mr. Gourlan and Mr. Langford. I have constituents who have parents and grandparents who have visited a number of times and are over the age of 70. And these families are finding that the cost of insurance is so high that they have to cancel their visa application, and the parents and grandparents are unable to come to visit. So I'm wondering if you have a suggestion or recommendation, something to propose about how we can reduce the insurance costs while, of course, making sure that there are medical services available. Yes, there is a solution which is very practical. The super visa is not mandatory. People could apply to come to Canada on a temporary basis for a limited period. Who says that they have to apply for a full year or 2 years for that length of stay in Canada? They can choose to come for a few weeks, 1 or 2 months. The key thing is that there has to be an operational directive indicating that if a parent or grandparent applies for a 2-month stay, then the family has to amend an application and perhaps apply for a super visa if the authorities are concerned. So A super visa shouldn't be required for a short visit. If the suggestion is made for a super visa, then that can be done. Mr. Langford, do you have anything to add? I would like to hear your point of view on this.
Other witnesses who have said that the cost for buying insurance for a full year if you're not going to be here doesn't make sense. And Mr. Curlin is suggesting is that a parent or grandparent who's elderly not apply for a super visa, but instead apply for a temporary resident visa and then have insurance for an appropriate period when they're coming to Canada. So they are reducing the cost. We would not be in favor of simply waiving, all insurance requirements so that an elderly person could come to Canada without medical insurance. That would not be advisable, but I think there are creative ways to reduce the cost, and I think they've been mentioned by the other witnesses.
Thank you. Autre question.
I have another question, and I want to come back to Ms. Ahmad. I'm sure that you have had the opportunity to note the impact of the possibility for people to bring their parents or grandparents to Canada for an extended time. So could you tell the committee what you have seen regarding the economic, social, and cultural benefits of having the parents or grandparents coming?
I'll try to do it in English.
No, that's fine.
Sorry for interrupting. Time is up for Mr. Al-Khouri. You will get an opportunity in the second round. We will now proceed to Mr. Brunel Desep. Mr. Brunel Desep, you will have 6 minutes. You can please begin.
Thank you, Madam Chair, and I want to thank all of our witnesses who are here this morning to help us come up with recommendations or with their recommendations. I have a question for Mr. Curlin. Something that's bothering me. The super visa would enable people to have better conditions, but we have to make sure that people leave Canada once the visa time is up. So is there a problem with this? Because we say you can come for an extended length in time, but then what about their application for a permanent residency? Thank you. That contradiction is really inherent to the legislation. We've got this doctrine of dual intent. So we have people that are here for a temporary period, but then might apply for permanent stay. Well, this is a problem, and in fact, we've got this dual intention that is inherent to a number of programs. So, for example, we have students who come. They're told they have to go home afterward, but there's a desire to stay and processes for that. So the system as such, can it not be improved so that we can eliminate this dual intention issue? Well, I think in December there was an effort. The Prime Minister instructed ministers to the effect that if there is a couple that wishes to come, instead of refusing people they can be let into Canada if they are applying for residency, and that eliminates this contradiction. Could we not do something more substantial? Because it seems to me G7 country just taking a kind of a lax approach, that's problematic. So I would like to see if Mr. Langford from CILA to see if there are suggestions from their side.
Wait, Mr. Langford.
Well, thank you for the question. I think, if you're suggesting, and if your main point is that there's a problem on the back end with super visa holders and their compliance with the expiry of their visa, and them leaving Canada, that compliance issue exists for all people who enter Canada temporarily. So, enforcement really does fall to Canada Border Services Agency when people are seeking admission to the country, and also if they're overstays. It is a major problem for the country and for every country. In fact, we're not unique in Canada. We have to deal with people that are overstays. So I don't think the issue is unique to super visa holders, but the one thing that Sila said in our opening statement is that the change from 2 years to 5 years, that sort of weights it more in favor of these people severing ties with the country of origin, not maintaining their residence, and being less inclined to leave Canada. So that would be the reason that we actually don't see the change necessary from 2 years to 5 years for a single stay.
Merci, monsieur.
Thank you. Ms. Salman, I have a question for you. Kyle Seaback has sponsored this bill, and he said 2 weeks ago that perhaps the minimum income level should be reduced or eliminated. What do you think of that?
Thank you. Well, at ACCT, we know that sometimes immigrants living here may not have a very high income, but their parents living abroad, they have assets and they have resources, which is why we included the recommendation to give the option for parents to finance their stay. When local immigrants have to meet a certain income threshold, sometimes if they are below that threshold, this prohibits them from bringing their parents from abroad. But in fact, there are resources that can be used. The immigrants just don't have them. The parents have them. We do believe that yes, the income threshold should be studied and perhaps lowered.
Merci beaucoup, Madame.
Thank you very much, Madam Chairman. How much time do I have left? You're on mute, Madam Chair.
Okay.
Thank you. We will now proceed to Ms. Kwan. Ms. Kwan, you will have 6 minutes for your round of questioning. You can please begin.
Thank you very much, Madam Chair, and thank you to all the witnesses for their presentations. I'd like to ask all the witnesses this question. The system to which we have at the moment do not allow for an appeal process. So that is to say, under perhaps certain extenuating circumstances, a person might all of a sudden disqualify. Case in point, I actually had someone tell me that in their final year of meeting the income requirement, their baby came early. And as a result of that, they had to go on mat leave, literally in the last month of that requirement, they had to go on mat leave. And as a result, their income dipped when they went on mat leave, and that disqualified them, actually, having waited this entire time and getting the draw and all of that. And there's no appeal mechanism to say, can there be an extenuating circumstance to understand the situation and allow for the application to proceed. Because right after the mat leave, for 1 month, the individual went right back to work and their income went right back to where it was before. So I'd like to ask the witnesses to comment on whether or not in these provisions in Mr. Seaback's bill, if we should actually include a provision that would allow for the minister to consider a mechanism for appeal in this regard. Maybe I can start with Mr. Kirtland, and then we can go through to the other witnesses.
There is an appeal to the appeal division of the Immigration Refugee Board when the minimum income threshold fails as a test. So there's that, but that takes a long time. It may be an idea to have a kind of a second set of eyes, another decision maker look at cases where temporary status applications have been declined. That's been posited for some time among policy analysts. So I'll allow my good colleague Vance to take this one.
Thank you, Mr. Kurland, and thank you, Ms. Kwan, for the question. Ms. Kwan, I think that the situation you outlined happens to a lot of people, and there should be some appeal process. For a visa application, I believe there's an application could be made to federal court for leave and for judicial review of the decision, and that would be determined based on whether the officer that reviewed the visa application fettered his or her discretion. And I don't think that's also impractical, long, and expensive process, and it would be ultimately based on whether the person met the income requirements. So, that may not be worth pursuing. Another idea I had, and others can comment, but the minister could issue a temporary resident permit for someone who didn't meet the requirements. So that's one idea. The third thought is that these visas are issued, and the program criteria are developed through ministerial instructions. And one of the questions that was considered in the past meeting on May 17th of this committee on this bill was whether IRPA should be amended, or the regulations should be amended, or it should be dealt with in another way. Our submission would be that it should be continued to be dealt with by ministerial instructions so that there could be more flexibility. And I would suggest that the flexibility be built into either, if studies, the research shows that it's warranted, reducing or eliminating the low-income cutoff, or allowing for credit for example, assets and resources that the parents and grandparents themselves have. You can't necessarily post a bond. We might not like to go there, but if there's another way to guarantee that those resources can be accessed, then I think that would be a good idea as well. So I think there are a range of options, and I think this could be dealt with within the program itself.
Thank you. I would want to highlight the current process, of course, is that you have to go to federal court, and it is an onerous process, as you indicated. A lot of people would give up, actually, at that level. But if you allow for an appeal process that's not requiring it to go to federal court, and where the government or the officials can actually make that determination, or even the minister can make that determination, I think that would actually be much more efficient. Actually, Ms. Salmon, I don't think you had a chance to respond, so I'm going to give you a quick chance to respond before I follow up.
Actually, if you don't mind, Ms. Ahmad had her hand raised for this question, so I'm going to go to her.
Thank you. Ms. Kwan, first of all, we do agree with you 100% in terms of the fact that for a lot of the immigrants that we serve, for the communities that we come from, they are overrepresented in precarious employment, and they are to produce a proof of 3 years of income, even minimum threshold income is too much to request. If you're going to purchase a home, the bank doesn't ask for 3 years of the same level of income in order for you to be able to get the mortgage. So for us, I'd like to stress that although we do welcome the improvements on the bill, because we believe the families have the right to bring their parents and grandparents, but we do see it as only an alternative to them sponsoring, or while waiting for the sponsorship to kick in, they'll be able to be reunited.
Sorry for interrupting, Ms. Amal. Time is up for Ms. Kwan. We will now proceed to our second round, and we will have Mr. Benson. Mr. Benson, you will have 4 minutes for your round of questioning.
Thank you, Madam Chair, and thank you to all the witnesses for being here today. In terms of talking about the minimum necessary income, some critics have suggested that we should look at it on a regional basis. The costs are different in different parts of Canada, and it's unfair for somebody living in the prairies to have the same income as somebody living in Toronto or Vancouver. Can all the witnesses just give their comments on if that should be a consideration when that is looked into?
Well, I can go first if that's okay this time. There are certainly complexities that'll be introduced if you have regional sort of income cutoff requirements that will vary, change over time, and have to be kept up to date. One suggestion might be rural versus urban income requirements, depending on the location of the family. That's obviously going to be a difference, but it's something to manage if you start to do that. So I think you'd have to weigh that in the balance with whether you just reduce overall.
Okay. In regards to that, other critics have said it should be totally removed altogether. There shouldn't be any minimum requirement. What are your thoughts on that, and what would be the negative impact of that?
Money. It boils down to money. It's not an exciting immigration selection category in the first place. You're either related to the parent, grandparent, or you're not. Still, if we were to allow limitless or zero income, I should say, as a threshold, I don't know how many applications we can expect to pour into the system, but we can make the problem go away by giving a credit for each young person in that family of $5,000 by reducing the threshold based on family size. Under those circumstances, I think the regional issue will dissipate.
I found it interesting that yourself and Mr. Langford both suggested that the 5-year period was probably not going to be a good idea, and that we don't really need that either. And I was wondering if it's just a case of we're not explaining to the applicants and the visa holders how is it a question of just educating them better on how our current system works, that you could be here up to 9 years right now, and that and that was what Mr. Langford said earlier. So it's already works. We just need to educate people about it better.
I don't know if others have comments, but I would agree with that information needs to be very clear. It is in the program instructions. It is clear. So there could be more information, better information for parents and grandparents and their children who are in Canada. That's how it works. And if you have a good immigration lawyer, it'll be explained to you for sure.
Okay.
Can I comment on this, please?
Mm-hmm.
Is that okay?
Yes.
But they have to leave after 2 years, and this is also costly. And if they needed to stay, for example, for 3 years, and then after 2 years to reapply again and to leave and to come back, that's why we kind of welcome the fact that if they want to stay for longer periods of time, especially those who are waiting for their sponsorship applications to kick in, then it saves them money. Thank you.
Okay, well, thank you very much.
Time is up for Mr. Benson. Thank you. Just a reminder to all the members and the witnesses, please address all your comments through the chair. We will now proceed to Ms. Lalonde. Ms. Lalonde, you will have 4 minutes. You can please begin.
Thank you very much, Madam Chair, and certainly I want to say thank you to all our witnesses today. And I would just like to maybe come back to Mr. Langford's comments regarding keeping the super visa in ministerial instruction. Can he expand a little bit on what the limitation or challenges would be if it was moved under the authority of the IRPA?
Well, the answer would be, Madam Chair, flexibility. So amending IRPA to provide a different duration, amending IRPA to do other things that are proposed in the bill, allowing foreign insurance providers or reducing the minimum income. These are all sort of programmatic requirements that the only one that I would see would be worthwhile considering putting into the act or the regulations would be the duration of the visa. But I think that the Canadian immigration system would benefit from the use of ministerial instructions to adjust and change something like the duration of a visa without having to amend the act. I think there are more fundamental things that would be done in the legislation. I would also agree with caution about the use of ministerial instructions for many things, and that when ministerial instructions are used, the government have an obligation to report to Parliament at least annually on the use of ministerial instructions.
Thank you very much. And maybe if, through Madam Chair, to your knowledge, are there any other temporary visa programs that is built into the IRPA, Mr. Langford?
I think, Madam Chair, in IRPA, there are the outlines for programs, visa programs, but the specifics are in the operational bulletins and the guidance that's used by the department to administer them. So I don't want to give you, I can't say definitively that there are no specific programmatic visa requirements in the Act or regulations, but generally the criteria that are used to evaluate whether how the structure of a visa program and its requirements are in the program itself.
Thank you again. And maybe if I can just, my colleague, Mr. Faisal, had tried to have an answer from Madame Ahmad and Salman regarding, and I'm just going to go by memory a little bit on the committee to tell us the value of economic, social, and cultural value of family being reunited. And I'm wondering if we could finish on this, Madame.
Should I take this?
Madam, Ms. Lalonde, who you directed your question to?
Well, it was either, it was my colleague from the Arab Community Center, Madame Ahmad, or Madame Salman. I wanted to give the opportunity to Madame Ahmad to finish sharing with us, if I may, Madame Chair.
Yes, please. Madame Salman, you can begin.
Thank you. Thank you, Madam Chair. I'm going to comment on two of the questions that were just addressed concerning the income and the length of stay from 2 to 5, and we do support lowering the income threshold and the extension from 2 years to 5 years. 2 years is a short period, like Ms. Ahmad mentioned, and maybe too onerous for reapplication. But 5 years is a reasonable period for a reassessment. Maybe even the immigrants' socioeconomic situation has changed. Maybe they, they have higher income now, or like if it's lower income, and then things need to be reassessed. So we do believe the 5-year is useful. The 5-year improvement is a useful change.
Sorry for interrupting, Ms. Salman. Time is up for Ms. Lalonde. We will now proceed to Mr. Brunel Desaep for 2 minutes. Mr. Brunel Desaep, you have 2 minutes. You can please begin.
Thank you, Madam Chair. Well, I want to thank the witnesses, because this is the last time I will be speaking with you this morning. So, Ms. Ahmad, I think you are the only person that I have not addressed a question to, and so I would just give you the opportunity to say whatever you would like to say for the minute and a half about this bill that has brought us here. So please say anything that you would like to. Thank you.
Thank you. Thank you. Well, the only thing I can say is that when we're thinking of families, we're thinking about real lives, and we're thinking about the right of families to be reunited. And we think that we shouldn't put a cost and benefit to the taxpayers above having the families the right to be reunited. But at the same time, having them come on temporary visa, visitor's visa, is also very, a lot of people get declined because the parents have to prove there that they have the income, that they're going to come back. So the super visa came, like we mentioned before, came as a welcome measure in order for the families to be reunited. And it's too bad that we didn't get into talking about the benefits of having grandparents and parents, but I think all of us come from families, and we do realize the value of having parents and grandparents around in terms of the language, in terms of the passing on the heritage, in terms of the wisdom, in terms of the having that connection. So for us, it's a matter of making it easier for our communities to be able to be reunited with the families. Whatever bill comes in that is going to make it easier for families, less costly, and from a human perspective, get the opportunity for families to be reunited, we obviously welcome it.
Sorry for interrupting, Ms. Ahmad. Time is up
Merci
for
beaucoup.
Mr. Brunel. Mr. Brunel Desep. We will now end our panel with Ms. Kwan. Ms. Kwan, you have 2 minutes. You can please begin.
Thank you very much, Madam Chair. I just want to note that actually in the previous Parliament, the 2015 Parliament, this issue was actually studied by committee, and witnesses indicated all the concerns that people have raised here, including the income threshold, it being too onerous for parents, grandparents, reunification. And at that time, recommendations were made, by the way, to the government, to which, of course, those recommendations sat on the books, and 6 years later, nothing's happened. So I'm concerned that the idea that somehow this should be dealt with through instruction, ministerial instruction, would actually do the trick, because we know that so far it hasn't. And so to that end, my question to Ms. Ahmad is this. Is it important then for us to clearly lay out what measures should be put in place to reduce the onerous requirements for parents, grandparents, sponsorship? Because if we don't and rely on the government to act on their own, and so far, at least in my tenure, in the last 6 years, nothing has happened.
Thank you. I'm not really sure how to respond to this because I'm not an economist or a politician or, the only thing I can say is that we definitely need to have flexibility. We need to look at the human aspect of it, and we need to make sure that people are able to be able to bring their families, their parents and grandparents here. I'm sorry that I'm not able to comment more. I don't know what measures could be taken in this regard. But
just
I agree, it's prohibitive. Mm-hmm.
May I add, if we have?
Sure, go ahead.
Just to add to what Ms. Ahmad mentioned, I do believe that the community development or community support sector can make meaningful contributions in terms of offering strategies and working with the government on and not leaving the government on its own, working on this and perhaps suggesting improvements. I hope
thank you, Ms. Salman. Time is up for Ms. Kwan. And with this, our first panel comes to an end. On behalf of all the members, I really want to thank all the witnesses for your important input as we go through the consideration of the Private Members Bill C-242. So with this, I will suspend the meeting for 2 minutes so that the sound checks can be done for the second panel. So the meeting is suspended for 2 minutes. Madam Clerk, if you can do the sound checks for the next panel. Thank you again to all the witnesses for appearing before the committee. order. I would like to welcome the officials from the Department of Citizenship and Immigration for appearing before the committee today as we go through the consideration of Bill C-242, an act to amend the Immigration and Refugee Protection Act, temporary resident visas for parents and grandparents. I would like to welcome Michelle Kingsley, Director General Immigration, James Saylor, Director Immigration Program Guidance, and Ben Michel, Counsel. Welcome and thanks for appearing before the committee. You will have 5 minutes for your opening remarks. You can please begin and then we will go into our round of questioning.
Thank you, Madam Chair.
I'm pleased to be with the committee today, and I would like to take a moment to acknowledge that the land from which I'm joining you today is the traditional unceded territory of the Algonquin and Anishinaabe Nation. As the Director General of the Immigration Branch within the Department of Immigration, Refugees and Citizenship Canada, I'm happy to speak today about the Super Visa and the proposed amendments presented by Bill C-242. I'm joined by my colleagues James Saylor from the Operations Sector, as well as Caroline Forbes and Ben Mitchell from the Departmental Legal Services.
The importance of family reunification and the social, cultural, and economic benefits of reuniting parents and grandparents with their loved ones in Canada. The Super Visa was established in 2011, and since its introduction, it has been a popular and facilitative multi-entry visa that successfully reunites families in Canada. The Super Visa is valid for up to 10 years, and it allows parents and grandparents to stay in Canada for up to 2 years each time they enter the country. They can also extend their stay from within Canada for up to 2 more years, with no limit on the number of requests for extensions within the country. There are also no limits on the number of individuals who can apply for the Super Visa, and IRCC approves approximately 17,000 Super Visas each year. Because of longer stays, applicants must meet additional criteria, including a one-time standard medical exam at the time of application, private health insurance from a Canadian company, and financial support from a host who must meet a minimum income cutoff. These safeguards are in place to protect clients and our health system. Madam Chair, I'd like to now address the proposed changes to the Super Visa brought forward by Bill 242. With regards to authorities, Bill C-242 proposes that certain conditions of the Super Visa be established in the Immigration and Refugee Protection Act. Currently, the Act serves as a framework legislation and authorizes the making of regulations and ministerial instructions to deliver programs and services. Program criteria for the Super Visa are established in ministerial instructions and not the Act. This approach allows for program changes to be pursued quickly to respond to emerging needs of clients. The proposed changes to Bill C-242 would mean that future adjustments could only be done through legislative procedures which can require years to complete. Bill C-242 also proposes to establish the length of stay in the Act, increasing it from 2 years to 5 years per entry. As I mentioned, under the current Super Visa, clients can request extensions while here, meaning that they already have the possibility to stay for 5 years or even longer without needing to leave Canada. Another important feature of the bill would allow private insurance from international providers to be designated by the minister. Under the current Super Visa, insurance from a Canadian company is required because we know these providers, they're regulated in Canada and they're reliable. IRCC does not currently have expertise in the international health insurance market, and allowing foreign providers, as proposed by the bill, would require consultations with health sector experts as well as with provinces and territories to determine which criteria should be included in such a designation scheme. Simply put, there are many unknown impacts of broadening health insurance to foreign providers which require further examination. Enfin, le projet de
Bill C-242 proposes a report that would be tabled to review the financial criteria for the super visa. Current income requirements are based on the LICO, the low income cutoff, defined by Statistics Canada, and are intended to ensure that visitors are supported by their host. The government agrees with the requirement to table a report on the impacts of lowering these standards.
For Dufferin Caledon and all committee members for bringing forward Bill C-242. The super visa is an important pathway to reunite parents and grandparents with their loved ones in Canada. We continue to review existing criteria, and we welcome opportunities to strengthen our supports for family reunification. I'm happy to take your questions now. Merci.
Thank you, Madam Kingsley. We will now proceed to our round of questioning. We will begin our first round with Mr. Janice. Mr. Janice, you will have 6 minutes for your round of questioning. You can please begin. A reminder to all the members and the witnesses that all the questions should be directed through the chair. Thank you. Mr. Janice.
Thank you so much, Madam Chair, and thank you to the witnesses, and if they're still listening, to the witnesses from the first panel as well. I wonder if all of the witnesses could comment on the issue of the income cutoff a little bit more. This is an issue that's addressed in the bill, and in particular, I guess the presumption of even having an income cutoff is that there is that those who are coming are kind of drawing on the resources of those who are providing for them, when in fact, as we've heard at this committee, in many cases there is, if it's not too crass to say it, an economic benefit to the family that's associated with the presence of parents and grandparents in terms of various kinds of support. So I wonder if you could speak to, in that light, does it make sense to have an income cutoff at all?
Thank you, Chair, for the question. I think if we take a step back and we consider Statistics Canada's definition of the low-income cutoff, I think that that's a good place to start. So the low-income cutoff is the threshold below which a family will devote a much larger share of its income in comparison to the average family to basic necessities such as food and shelter and clothing. So that is why it was established as the threshold for the super visa, because it really takes into account the basic necessities that extra family members would bring. And it is meant to balance the fact that it is a longer stay visa and to make sure that clients are appropriately supported while they're here. That being said, the government agrees that this is something that should be continually revised, and we'll be examining it, and the minister will be tabling a report if this bill is adopted on the low income cutoff and whether other considerations, which including those that have been raised by other witnesses, should be considered.
Thank you. Yeah, and I mean, I won't press the point with you, but just sort of for the committee's reflection, I mean, that does seem to still kind of come from a perspective of assuming that that there is a cost to the family instead of an economic benefit. It may be that families who are struggling economically, one of their big challenges is childcare, and having a supportive grandparent present will allow them to improve their economic situation. I wanted to drill down further on the issue of ministerial instructions. Some members of the government have on this committee said action could be taken by ministerial instruction on some of these issues. The nature of a bill, especially a private member's bill, is it takes a long time for it to wind through the process. We're trying to deal with this bill as quickly as possible, but it will go through, assuming everything goes well, report stage, third reading, likely committee study at the Senate as well. The government could move forward to demonstrate its commitment on some of these issues on ministerial instructions right now, could it not, even while the bill is proceeding? So it doesn't make much sense to me that they would argue we don't need these provisions because we can do it by ministerial instructions when they have actually failed to act when it comes to ministerial instructions. Could you maybe just clarify the timelines that would be involved in ministerial instructions if the government were to try to move on some of these issues right now?
Thank you, Chair, for the question. That's correct. Legislation can take months and years to pass, whereas ministerial instructions, depending on the complexity of the issue involved, can be drafted in weeks to months with, a level of flexibility that is really desirable in these types of situations. So I would say in the context of the super visa, new ministerial instructions could be drafted and signed in a question of weeks.
Okay, but to your knowledge, is the government in the process of doing that at the moment, of preparing revisions or instructions that address the issues in this bill?
I think the government is watching closely what's happening with this bill and is open to making changes to enhance the super visa as well as other lines of business.
Right. I guess my point is, though, that it seems that the argument being used by some is to say, well, we don't need certain provisions, or we shouldn't have certain provisions that are in this bill because the government could act by ministerial instructions. And my point is, well, the government could act by ministerial instructions by now. They could have acted by now, and they haven't. And if they want to act by ministerial instruction, I guess one way they could strengthen their case is by moving forward with those actions right away. And you're confirming that the government could do so. They could do so in a matter of weeks, but they have chosen not to, which from my perspective strengthens the rationale for legislative measures, because it shows that the government has been unwilling to make some of these changes, and that's where you need legislation. It's often when you see the government unwilling to move on something, then legislation becomes important because it requires government action. I've got 20 seconds left. I don't know if you want to comment on that. That's mostly just me sharing an opinion. But did you want to comment on any of that?
I'm sorry, Chair. Was there a specific question that I could answer?
I guess just the thought is, what is the impact on the government's rationale for saying this should be in ministerial instructions when the government hasn't actually brought in ministerial instructions that respond to the concerns raised?
Sorry for interrupting, Mr. Jennis.
Okay.
Your time
Thank
is
you.
up. You'll get an opportunity in the second round. We will now proceed to Mr. Ali. Mr. Ali, you will have 6 minutes. You can please begin.
Thank you, Madam Chair, and thank you to all officials for being here. Through you, Madam Chair, I would like to better understand what it means that this bill proposes changes to the Immigration and Refugee Protection Act, when the program in question, the super visa, is currently under the authority of ministerial instructions. To be quite honest, I'm not entirely sure that everyone has a full understanding of what ministerial instructions are and how they differ from legislation. If we set the changes in C-242 in legislation, what will that mean that next time the program needs to be adjusted to reflect the needs of clients? Anyone can jump in to answer, please.
Thank you, Chair, for the question. So as I was saying in my opening remarks, the Immigration and Refugee Protection Act is a framework legislation, and any changes to the Act would mean that any future programmatic changes would have to be done via legislation again, which can take months or years. And so changes keeping these provisions in the ministerial instructions gives flexibility to any minister to be able to introduce changes. I might turn to Council to elaborate, to Mr. Mitchell to elaborate on the benefits of legislation versus ministerial instructions.
Sure. Thank you for the question, Madam Chair. So essentially, ministerial instructions in the IRPA, IRPA contains various provisions which allow the minister to issue special instructions to immigration officers that enable the government to best attain its immigration goals. Ministerial instructions can touch on a diverse range of issues, from temporary residence processing, or in our case here, the super visas. Whereas, as my colleague, Ms. Kingsley, was previously mentioning, IRPA changes to the actual act itself will require longer legislative changes that take much longer to do.
Thank you. I'm understanding from your previous answers that your opening and your opening remarks that placing the super visa under the authority of IRPA will make it much more difficult to change in the future. Bill C-242 calls for the minister to table a report about reducing the minimum income requirement of the child or grandchild in Canada. If that report shows that reducing this income requirement would be appropriate, what would have to happen to make that change in IRPA versus if the changes only needed to be made to ministerial instructions? My question, can you give some examples of instances when changes to the super visa or other temporary residence streams were able to be done expeditiously through ministerial instructions? And B, are there any other temporary residence programs that are enriched in IRPA? Thank you.
Thank you, Chair. I don't have any examples of when ministerial instructions brought in changes to a temporary resident pathway. And I would turn to Council to confirm, but to my knowledge, there are no temporary resident pathways that are contained in the Act itself.
Thank you. Do you want to add, Mr. Mitchell? Something?
Yes, sorry, just to confirm that is correct. Temporary residents, the framework for temporary residents are set out through the regulations, and the ministerial instructions can be used to complement those with selection criteria and conditions.
Thank you. During his appearance at this committee on May 17th, the sponsor of Bill C-242 stated that he had very little faith that the government would bring about the changes proposed in the bill, if not done through legislation. It's my hope that your appearance here today can help us to convince the sponsor that his concerns are unfounded. In your view, do the changes proposed in the bill align with any of the government objectives?
Thank you, Chair. I think that the objectives of the bill to recognize the social, economic, and cultural contributions of parents and grandparents to not only their families, but to our society are completely aligned with government objectives. The current super visa provides for an initial entry of 2 years, but it also provides for unlimited renewals from within Canada for periods of 2 years at a time. So I believe that that's completely aligned with the objective of the bill of longer stays as well. So I do believe that the objectives of the bill for family reunification, recognizing the benefits and for longer stays are already provided through the current super visa, and that the government welcomes furthering those objectives, and that really the issue is to be consistent with the framework legislation that we have and to keep it in ministerial instructions rather than including it in the legislation, which would result in future changes being extremely cumbersome, difficult to pass.
Sorry for interrupting, Ms. Kingsley. The time is up for Mr. Ali. We will now proceed to Mr. Brunel Desap for 6 minutes. Mr. Brunel Desap, you can please begin.
Thank you, Madam Chair, and I want to thank our witnesses, the officials from the department who are here today. I have a few specific questions for you, and you can decide who can answer the best. In 2016, a lawyer pointed it out to the committee that it was difficult for widows to come because it was difficult to convince visa authorities that they would leave after the time. So if the period for super visas was increased to 5 years, what would be the impact on widows and other vulnerable persons? Thank you, Madam Chair, for that question. Well, it is true that the dual intention applies, as it does in all of our programs, the need to leave Canada when the temporary resident permanent expires, continues to coexist with the desire to stay, then people can apply to become permanent residents, and this may or may not be awarded because we need assurance that when the permit expires, the person will leave Canada. I don't believe that what is being reviewed here will really change that analysis. I'll see if Mr. Sila has something to add, perhaps. No, I just want to come back to what you've just said. The question isn't really whether the person will get permanent residency. It's whether the dual intention in the case of a widow or another vulnerable person makes it more difficult to get the super visa. So it's not a case of whether the person leaves when they should or not, but whether these people are going to be affected in a particular way, as the lawyer raised in 2016. These people are more often refused than others. I don't see how someone who is vulnerable, a widow or someone else, would have a lower chance of being accepted for this type of visa. I think they have the same chance as others. So I don't see how these changes would make it more difficult to get a super visa, but I would have to maybe look at the remarks made by that lawyer in 2016 to be able to comment. Perhaps Mr. Seiler has something to add?
Thank you, Madam Kingsley, and thank you to the chair for the question. I would just agree with what my colleague from the department has just said, that in fact, the additional period of time prescribed in the bill of up to 5 years could in fact make it more difficult for officials to find that the person is a temporary resident with the intent to leave Canada. Often the longer that someone stays in Canada, the weaker their connection to a point outside of Canada can become. And therefore, with a shorter project of entry, as is currently the case, it may be easier for anyone, including in a vulnerable situation, to obtain the super visa.
Merci pour ces...
Thank you for those answers. Perhaps we can provide you that testimony from 2016 here before the committee, and perhaps the Library of Parliament could do this and share it with you. There are some critics that feel that the department has very high requirements because families have to have a consistent income which cannot fall before the threshold. And we know that we've had a very difficult economic time with the pandemic. And of course, we know that views are different depending on the economist that you might consult. So do you think that this bill would fix that situation? Thank you. This is an interesting question. Having to report to the House on the minimum income threshold will give an opportunity to address this issue and the concerns raised by the previous witnesses. That is, whether temporary changes in income shouldn't be taken into account. So there could be changes made to those rules, and the minister could include those concerns in the reporting to the House. Thank you, Madam Chair. How much time do I have?
Time
Il
is
me
up.
reste plus de temps. Merci.
I'm out of time. Thank you.
Now proceed to Ms. Kwan. Ms. Kwan, you will have 6 minutes. You can please begin.
Thank you very much, Madam Chair, and thank you to the witnesses, the officials here. On this question around appeal process, we discussed it just briefly in the last panel, and it was cited to say that people can always go to judicial review, federal court, and so on and so forth, which is an onerous and expensive process. So I guess based on the information that you have, could you advise the committee how often is that appeal process exercised by people who's been rejected in the parents-grandparents sponsorship program?
So to be clear, Chair, is the question around the parents and grandparents sponsorship program or the Super Visa program?
Actually, I'm interested in both because it's okay. Relevant. Super Visa is obviously a surrogate for the parents-grandparents sponsorship program. Do you have that information that you can share with the committee?
I don't have information on the number of times that those processes are, those recourses are pursued. I'd turn to council and see if council has that information or my colleague in operations.
Apologies, Madam Chair, I don't have that information.
And nor do I, Madam Chair. Thank you.
Fair enough. Maybe we could have that information submitted to committee for our review. The other piece is this, related to the issue around income threshold. There's been a lot of discussion about this. In fact, I remember distinctively back in the first parliament when I was elected, this issue came up at the CIMM committee, and there was extensive discussion with witnesses as well. And then along with it, there were a series of other recommendations. But to date, as far as I could tell, none of those recommendations have been acted on, including the request for the department to look into the contributions of parents and grandparents in other ways to Canada's cultural mosaic as well as our economic, as well as our economy. Why is that? Why has the government not actually responded and provided information with respect to those critical questions that is now before us once again?
Thank you, Chair, for the question. Officials have been continuing to look into the various recommendations that the committee has made in the past. Following those CIMM recommendations, officials did consult with health insurance industry on the super visa requirements. Those discussions actually ended up having stakeholders raise concerns more around actually whether insurance was sufficient, given the demographics of the population and their likelihood of having variable health statuses, which of course would lead to more expensive insurance. In 2020, the length of extension that one can apply for from within Canada was increased to 2 years, really providing for an opportunity.
Sorry, I'm just going to interrupt here for a minute. I was asking more specifically about the recommendations on contributions of parents and grandparents culturally and economically to Canada. I don't believe any data or information has been provided with respect to that. I do want to ask about this question, though, with respect to parents, grandparents, and related to this. The suggestion was that this should be dealt with by ministerial instructions as opposed to legislation. And the argument is that it's easier for government, to act and less cumbersome. And then the counter piece, of course, is that without legislation, what will actually compel the government to act? Because so far, we haven't seen action realistically. And the whole idea with the super visa, really, in essence, is to fill in the gap of the lack of parents, grandparents sponsorship application process. So how do you answer that question? What can compel the government to act if we don't do this in legislation?
Thank you, Chair, for the question. So I would say that the objectives of the Act, which are to achieve longer stays, are actually already provided by the current super visa with an initial entry of 2 years, but with unlimited renewals from within Canada. And so, keeping it in ministerial instructions is not just a question of government facility, but also, should there be further changes that would be wanted, it allows for a faster, nimbler response for the benefit of clients. But I would come back to the fact that the goal of the legislation to increase the stays is actually already met by the legislation, by the current super visa, which is in ministerial instructions.
I guess if you talk to parents, grandparents, they may offer some other points of view with respect to that. On the issue around looking at insurance, one of the issues that did surface from previous committee review is the idea of allowing for parents, grandparents to access provincial insurance. Was that ever looked into?
Sorry, to access provincial insurance?
Yes, provincial MSP. In my province, we call it MSP premiums, the BC MSP premiums.
Sorry for interrupting, Ms. Kwan. Your time is up. You will get an opportunity in the second round. We will now proceed to Mr. Hallen for 5 minutes. Mr. Hallen, you can please begin.
Thank you, Madam Chair, and thank you to the witnesses, previous ones, and the officials for being here today. I wanted to kind of focus on the social aspect of this bill. I wanted to get feedback from each one of the witnesses, if each of you could speak to kind of let's look at it through the family and the social lens. We know that a lot of cultural communities rely on this super visa. It is our belief that it would strengthen the family ties and strengthen family structure in Canada. I'd like for each of you to comment on that, looking at that through that lens.
Thank you, Chair. I agree. I think that the super visa is an extremely facilitative tool, which has been used quite a bit since 2011. IRCC approves some 17,000 super visas every year, which means that parents and grandparents who contribute economically, socially, culturally to our communities and our country and their families, of course, are able to reunite. And again, that super visa has a validity of 10 years, and the initial entry is currently set at 2 years and can be renewed any number of times from within the country. And so really enables for that family reunification to continue without interruption should super visa holders continue to renew from within the country. I'm not sure if my colleague, Mr. Seiler, if council would like to add to that.
Like to respond to that? Okay. I wanted to get also your thoughts on what do you see a benefit in this? Because we see this like really big backlog right now in the immigration system. Would this visa help to alleviate some of that stress? Because there would be, in your opinion, would there be less renewals with this kind of visa?
I'll turn to my colleague in operations in a moment to see. I'm not sure if we have data on how many super visa holders are actually renewing, but presumably having a longer initial stay would result in fewer renewals. I think that is intuitively a conclusion that one can draw.
Thank you to the chair for the question and to my colleague. Indeed, it would potentially reduce the number of extension applications made from within Canada with a longer stay. Those, however, are not numerous at this point. Over the course of the 10 years that the super visa has existed so far, those extensions are only approximately 32,000 that have been submitted. When you look that approximately 17,000 super visas are applied for and issued each year, that's a relatively small number over the 10-year course.
Given that, whatever number it is or the impact of it, would you see a net benefit in this? Because would it help to alleviate some of the backlog or the pressure on processing times because it would be less renewals?
I would say that yes, any reduction of applications would have a potentially positive effect on the overall volume of cases that would need to be processed.
Thank you. I want to go back to just asking your opinion on whether it's the economic side of things or whether it's the social side of things. Do you see a net benefit of this, whether it comes to the family side of it or the processing side of it? Would there be a net benefit with the current bill the way it is right now? I'd like to get all of your guys' feedback on that.
Well, I think that quantifying social and cultural benefits is a very difficult thing to do. But I think that there's no question that there are economic, social, and cultural benefits to having parents and grandparents reunited with their children and grandchildren. You know, I think that the super visa does that currently, and it takes into account that balance of having longer reunification stays with some criteria that don't apply to a regular shorter 6-month visa.
Sorry for interrupting, Ms. Kingsley. Time is up for Mr. Hallan. We will now proceed to Ms. Kayabaga. Ms. Kayabaga, you will have 5 minutes. You can please begin.
Thank you, Madam Chair. I also would like by thanking our past witnesses and the witnesses that are here today. Thank you for taking the time to answer our questions today. I just want to ask a few questions. There's a question surrounding the medical requirements that someone has to have. If someone is in a current super visa holder and they want to extend their stay here in Canada, how does it work for their medical clearance? And do you have any? Do they have to have any medical exam and show proof of recent medical insurance every time that they apply for an extension?
Thank you, Chair. So the requirement to have a medical exam only applies at the initial application. So when the applicant sends in their first request for a super visa, that is the time when a medical exam is requested. If and when an applicant wants to renew their application, that medical exam does not need to be redone. They do need to continue to meet the insurance requirements.
Okay, so now another question I have is around the safeguards around insurance policies. What kind of mechanisms does ARCC have to ensure that these policies can guarantee coverage once the applicant is on Canadian soil in a timely manner? Like, is there a push around making sure that it's met on time?
Thank you. So currently, because the super visa requires the private health insurance to be provided by a Canadian provider, the integrity is ensured essentially by the fact that these are insurance providers that are regulated within the Canadian system. And so we know them and we know that they're regulated and that we can trust them. Should we consider foreign insurance providers the way that this bill does? we would really have to come up with a designation system that takes into account new criteria that the department doesn't currently have the expertise to develop. So we would have to work with provinces and territories and health experts to determine what are those criteria. Are they around the solvency of companies? Are they around, the compliance with laws and regulations abroad? What are the modalities of payments, including criteria, for example, around having payments at point of service to protect clients. So, and of course, ensuring that any designation scheme has ongoing monitoring to ensure that clients continue to be protected by anyone who's designated. So it's a complex issue that would just need to be really looked into in consultation with experts in the field and provinces and territories.
Thank you. It sounds like a very complex issue. So I'm going to ask further questions on that. There is no guarantee that there wouldn't be scams through that for applicants, because if there was to be, as the bill suggests, other insurance companies, there's no way to safeguard for people to make sure that they're not going to get scammed. And you wouldn't be able to track whether it can be delivered in a timely manner, which would cause and create more issues for the applicant.
That's correct, Chair. There is a higher likelihood of fraud, and that is something that we would be very concerned about. And we would need to develop really stringent criteria around all of these issues and ensure that there is a very close ongoing monitoring of any of thousands of companies that might be interested in being designated through such a model.
And just another quick thoughts on that. Would that take, how much time would that take if you have to consult with different provinces through their different healthcare systems, relatively, and I'm sure you can't really give me an exact answer on this, but I just feel like it would take time to get through all of that.
It would definitely take quite a bit of time to make sure that we get it right and to make sure that clients are protected from fraudulent actors, from possible companies that may not actually pay in time or may not pay up front. It would take quite a bit of time to determine all of that, and I can't really speak to how much time that might take.
Okay. Yeah, I figured you wouldn't be able to answer that. But so another last question on that same topic, just because it's a very interesting one. Especially...
Sorry for interrupting, Ms. Kaibaga. Your time is up.
Oh, no. Okay. Thank you, Madam Chair.
Thank you. We will now proceed to Mr. Brunel Desep for 2.5 minutes. Mr. Brunel Desep.
Merci. Thank you, Madam Chair. And once again, I want to thank the witnesses. This will be my last intervention today. What I'm understanding is that there seems to be a consensus about Bill C-242. There are no big obstacles regarding the measures that are being proposed. So, but can you tell us whether things can move more quickly so that the measures in the bill could be implemented more quickly? Is there any solution to that?
Merci pour la question.
Thank you for that question. Well, I think that, as you say, all of the parties support the principles behind the bill, and what the bill is seeking to do is to reinforce family reunification and to extend the amount of time that people can stay. The Super Visa already does that. It enables people to stay up to 10 years. So I think that the current Super Visa already does that. Well, in your opinion, how long would it take if the measures were adopted to put them into effect? Well, as I said, the Super Visa already does this. No, I'm talking about the changes under Bill C-242. Could ministerial instructions not be used to make this happen faster, given that there is a consensus here among all the parties? So couldn't that help? Well, I think, as I said earlier, the changes using ministerial instructions would be could take place in a few weeks. So I think it would be faster to do that than to send the bill to the Senate and get it back, perhaps, and so on. That would be faster? Yes. Thank you. I will now give the floor to my colleague from the NDP.
Thank you, Mr. Brunel de Sepp. Your time is up. We will now proceed to Ms. Kwan. Ms. Kwan, you will have 2.5 minutes. You can please begin.
Thank you, Madam Chair. I was asking previously the question around whether or not officials have undertaken to contact provinces and territories to see whether or not it is feasible for them to make available their provincial or territorial medical insurance coverage for parents, grandparents, with them paying for it, whether or not that is an option that could be entertained.
Thank you, Chair. To my knowledge, we have not asked provinces and territories about making their public health insurance regimes available to super visa holders. It is something that we could do. To my knowledge, it has not been done.
Okay. I would encourage officials to undertake that because that's another, I think, viable option as opposed to private insurers if the provinces or the territories are willing to provide for that at a cost. And that cost may be lower for parents, grandparents as well. With respect to moving forward on this, you know, part of the problem with these current parents, grandparents sponsorship program is that it's so limited. So few families could access that. And the issue with the income threshold is that it actually doesn't take into consideration contributions of parents and grandparents in terms of their cultural contributions and economic contributions here to Canada. And so should the government not be thinking about those contributions as they evaluate the financial requirements? And if so, how can they measure that and take that into consideration?
Thank you, Chair. So the member is referring to the Parents and Grandparents Sponsorship Program, which is the permanent residency program. And I would just highlight that the latest levels plan has the record admissions targets and has increased them considerably to 25,000 for this year, 28,500 for
Sorry,
next year,
just to interrupt, my question was about evaluation of their contributions economically, socially, and culturally. How is that being accounted for?
So I was saying earlier, it's really difficult to put an economic number on something like cultural and social contribution.
Sorry for interrupting Ms. Kingsley. Time is up for Ms. Kwan. We will now have 2 minutes for Mr. Hallan and then end the panel with 2 minutes from Mr. Dhaliwal. So Mr. Hallan, you can please begin. You will have 2 minutes.
It's going to be passed to Mr. Benzin.
Okay. Mr. Benzin?
Thank you, Chair. Just in regards to the health insurance, an earlier witness today said that his study showed there was 30 companies providing insurance. 30 companies is an extremely low number of companies. I think we need to have, you know, well over 100 or 200 or 300 companies that can provide health insurance, so we have a very competitive market. This would help reduce the prices. So would you agree with that we need to increase the number of companies that are providing health insurance?
Thank you, Chair. I mean, I think that increasing the number of insurance companies has the potential to reduce prices, but I think that there are a lot of questions around whether opening it up to foreign insurance providers would actually result in that. I think it's a really complex complex issue. And as I was saying, we can look at setting criteria for companies that would meet those criteria and make sure that we're protecting clients. And whether that designation scheme with added criteria, how the international insurance market would react to that, I think is an open question that we don't have an answer to. But, you know, nonetheless, the basic, yeah, excuse me.
I mean, nonetheless, the witness earlier was saying it'd be up to $5,000 a year for a person to pay for insurance that they might not even use, which is extremely expensive. And we need to find ways to make that market more competitive and lower these prices to make it more affordable for everybody. The other thing I'd like to mention is that we have.
Sorry for interrupting, Mr. Benson. Time is up for you.
Okay, thank you.
Now we will proceed to Mr. Dhaliwal. Mr. Dhaliwal, you will have 2 minutes. You can please begin.
Thank you, Madam Chair. I will carry on with Mr. Benson's question. Actually, it's very frustrating to see the insurance cost that is costing the children that want to bring their parents and grandparents on super visa. Not only that, but when they come here and at some point in time, you know, one of those cases have to go to the hospital. The insurance doesn't even cover the whole amount. So how can the government, I think there's a good idea that MSP, just like provincial insurances, if they can cover, at least then they don't need to worry about going back and forth between the insurance companies. I would like to see your comments, the panel members.
Thank you for the question, Chair. I think those examples that we see around parents and grandparents on super visas having issues getting, you know, insurance companies to pay for their costs and so on is reflective of how important it is that we have reliable, robust insurance for these super visa holders. The bottom line is the health and the financial security of these visitors. And I think that those examples just really underscore how much we have to be sure that we get it right, and that any insurance provider that is accepted in our programs will actually deliver what they promise.
I would also like to know what would be the impact of on the whole if the minimum necessary income requirement was reduced for children or grandchildren as an applicant for the super visa for their parents and grandparents.
Well, I think that that's what the report that the minister will be tabling as if this bill goes through will look at. And the threshold really is that's currently established really is the bottom line under which families have to devote a larger share than the average to basic necessities such as food. So I think that, you know, we're open to examining it. We're open to seeing what would be the impact of reducing it, and we'll table a report as to what the results of that study was if this was adopted.
Sorry for interrupting. Time is up. And with this, this panel comes to an end. On behalf of all the members of this committee, I would like to thank all the witnesses for appearing before the committee. With that, this meeting comes to an end. Is it the will of the committee to adjourn the meeting?
Adjourn.
Okay. Thank you once again to all the witnesses, and the meeting is adjourned.